If you're taking the real estate exam, landlord tenant law is not optional material. It's statutory, it's detailed, and it is timing specific. Today, I'm going to break down exactly what you need to know to be successful on the exam. We're going to go through the deadlines that you need to know. And let's start with tenancy types. A tenancy for years, that's a tenancy for a fixed term, a specified term, will automatically terminate at the end of the term. No notice is required. Don't confuse an estate for years with a periodic tenancy, an estate from year to year, because that one automatically renews. And you may have a question similar to a tenant's lived in a property for 3 years under a month-to-month lease. What type of tenancy does he have? And the key to the question is not how long he lived there. The key is that month to month. That's a periodic tenancy, and it will automatically renew. In addition to tenancy types, you also need to be familiar with security deposit requirements. And there are limits to security deposits. If you have a week-to-week tenancy, 2 weeks rent is the max you can charge. If it's a month-to-month tenancy, a month and a half is the maximum you can charge. And if it's a tenancy for greater than month-to-month, 2 months is the max. And all security deposits must be held in a trust account, or the landlord must post a bond. It is required under the security deposit legislation in North Carolina. Also, students get confused on the timing of accounting for the security deposits. The landlord must return the deposit or account for it within 30 days. If he can't fully account for it within 30 days, he's given a maximum of 60 days. He can do an interim accounting in 30 days and a final accounting within 60 days. And this must be done by the landlord to be in compliance with the security deposit laws. And that 30-60 is gold for the exam. Just remember 30-60, 30 days to account, maximum 60. And remember, in North Carolina, the landlord is required to maintain the property and keep it habitable. The tenant is required to pay the rent and keep it reasonably clean. So if a landlord doesn't maintain the property and keep it habitable, the tenant has the right to move out under the rules of constructive eviction. When he moves out, he gets his money back, his deposit and any advanced rent. He must move out, because if a tenant maintains possession of the property and the tenant maintains possession of the property and fails to pay the rent, then the landlord can pursue summary ejectment and regain possession of the property. Remember, in North Carolina, self-help eviction is not allowed. The landlord can't change the locks, can't turn the power off, certainly should never intimidate the tenant. Summary ejectment is the legal path to regain possession for the landlord. And constructive eviction is the tenant's right when the landlord fails to maintain the property. Now, when a broker manages property for others in North Carolina for compensation, it requires an active real estate license because it's a brokerage activity. And that means the broker has to comply with all the rules. The rules require us to have property management agreement. The rules require trust funds be held and accounted for properly. Record retention, 3 years. We have to keep all records. And trust money, any funds we receive, must be deposited in a security deposit. Security deposits must be deposited into a trust account. And the exam might ask you questions like, who signs the lease? Who holds the deposits? Who reconciles those accounts? And how long must you maintain those records? don't separate property management from brokerage law. In North Carolina, they're connected. And as we begin to think about those security deposits again, normal wear and tear is something we cannot charge a tenant for. Minor scuffs, worn sink basins, dirty carpet. Damage, on the other hand, we can charge against the security deposit. And damage would include pet damage, broken fixtures, holes in the wall. Remember, you can't use the security deposit for normal wear and tear. You can use the security deposit for damage, and you're probably going to get scenario questions on that. And lastly, fair housing laws are very integral to residential property management. And you may have questions about landlord-tenant relationships that are fair housing questions. So make sure you know your protected classes. Understand what a reasonable accommodation is. Know what you can ask and advertise and what you should avoid. And the exam blends the topics intentionally. And students lose points because they forget the 10-day notice requirement for non-payment of rent, the 30-60 rule for accounting for security deposits. They confuse tenancy types with the length of occupancy. They assume common sense instead of statute. Remember, the exam tests on laws, not feelings. Landlord tenant law and property management are predictable points on the North Carolina real estate exam. Know the timelines, know the deposit limits, make sure you know the eviction process, and a little bit about what's required for that security deposit in a trust account. You take charge of these details and go past that test. I'm Kim Stotesbury, and I look forward to hearing from you, and I especially want to hear that you passed that test. I'm Kim, and I'm going to keep it simple.